And we're live.
All right, everybody, this is House Education, Friday, February 21st, 2025. Committee members may have noticed that I put our new motto up on our whiteboard.
Oh,
Would anybody like to read it out loud?
Do it, Josh.
Clear, ambiguous.
So along the themes of clear, unambiguous guidance, I've asked folks from the NEA to join us today to essentially help us understand sort of what it means to have a collective bargaining agreement, a multi-year collective bargaining agreement in place at a time when you might be changing things, and sort of just some of the process, other implications that may be part of that period. Floor is yours. Welcome. Thank you very much.
Good morning, and thank you for having us. I am Jeff Van, the Executive Director of Montana, and joined today by.
I'm Rebecca. from General.
So we'll tag team this a little bit. We have some written testimony that Andy now has, and we'll walk through that a little bit. But so thanks for inviting us to talk about collective bargaining issues. Stop us along the way. You know, some subject matter experts around the table. So feel free to chime in, add to, or correct us as we go. So we're going to speak with you about collective bargaining issues because you're talking about significant consolidation of school governance structures, and as proposed by Governor Scott and other people, and discussions around the building. So while the governor proposes going from currently the 119 school districts to 5, our comments are not specific to the governor's proposal. But our comments are more general nature, and assume that there will be a significant reduction in the number of school districts. So we're making that assumption. If we're wrong about that, I think we stand. We'll break apart testimony in 3 parts: a brief primer on school employee collective bargaining, a brief summary of how collective bargaining was navigated after the passage of Act 153 in 2010 and Act 46 in 2015, and a brief summary of some collective bargaining concerns we see if there is a huge reduction in the number of school districts. Teachers and other school employees, will start with a primer. I used to be general counsel. This is what we kind of do a lot of in Vermont NEA, but school support staff and teachers bargain with their employing school board. So in other words, collective bargaining is employees who organize into a union who then bargain with their employer. So collective bargaining necessarily is bargaining with your employer, whomever that may be, wherever that may occur. And that results in a collective bargaining agreement, CBA, or a contract. Bargaining by teachers and their employing school boards is governed by the Labor Relations Act for Teachers, and it's found in Title 16, Chapter 757. And the school support staff are governed by the Municipal Labor Relations Act, which is 21 VSA Chapter 22. So for a quick sidebar here, school employees who are not teachers are considered municipal employees under the law, and so they bargain under the municipal employee law. These bargaining laws have been around for more than 50 years. It's well settled. I think both sides of the table understand the contours, the guardrails, the case law. It's pretty well settled in most cases, and there's occasionally questions that come along, but for the most part, it's pretty well settled. It's been around for a good while. School districts have bargaining teams composed of school board members, parents, local community members, etc., and correspondingly, local unions have bargaining teams composed of teachers or support staff. And in the model at Vermont NEA is Vermont NEA don't do the bargaining. We train our members to bargain on their behalf. We think it's much more, it's a much better system where the local leader, be it the teacher or support staff, understands much better the school situation and things of that nature, and they can bargain directly with their school board. So we don't go to the table. You hear oftentimes Vermont NEA is accused of hiring lawyers who go bargain and beat up on school boards. It's simply not true. First off, lawyers sitting right here, I've never bargained on behalf of school people, and I don't think Beck has either for local bargaining. But we hire mostly former teachers and support staff who we've trained previously, and then their job is to go train other members and teach them how to bargain and administer their contracts. So we have first grade teachers, we've had music teachers, we've had all sorts of teachers in our Uniserv ranks, is what you call them. And they work with members around the state to train them. So on a regular basis, so that's our model. And we don't bring lawyers to the table, and it's not how we work. Many years ago, you may remember the passage of Act 153. Somewhere here, I think it's 2010. That law created a voluntary merger incentive program that also included protections for teachers and school support during the merging of districts. So in other words, when 153 passed, there were protections put into the law so that when the schools were voluntarily merging, the school districts were voluntarily merging, people were protected in the transition. Makes a lot of sense. It did to us, enacted into law in Section 3G. Those mergers were voluntary back then. The law did require SU bargaining, so all bargaining took place at the SU level then. That's something Vermont ADA had been pushing previously amongst our members. We saw the wisdom in it and the efficiencies in it. So we were actually doing it, trying to encourage school districts to do it. The law made that required. It also required that special education teachers were employed by the SU, and it gave school districts the option of employing their support staff, paraeducator support staff at the SU level. Most, in fact, did that, but not all, for various local reasons. And I don't want to hazard a guess as to why those school districts did or did not. And then, of course, there was the passage of Act 46 in 2015. And again, there was teachers and support staff were protected during the transition. That was laid out almost identical to what was in Act 153, but it set out protections for folks so they wouldn't lose their jobs. So, for example, in the written testimony, you'll see the new district or SU had to hire the employees of the merging districts. They had to. They needed school employees. There's no question they needed them. So they had to hire the people who were coming from the merging districts. The employing new entity had to recognize the union as the certified collective bargaining agent. There was no question about having to go back for another election of that sort. And it required that both sides try to attempt to reach an agreement prior to the first day of the new existence of the new merging entity. So there was some encouragement to get to a new contract. And there's some details in our written testimony. The other thing is retirement. As you may know, the teacher's retirement system requires all licensed teachers in Vermont, including the teachers at the 4 historic academies, to participate in the teacher retirement system. So that's a contributory plan. Teachers contribute towards their pension. Likewise, the municipal employee system, retirement system, Beamers, most school employees, but not all, the school district can decide, and locally they decide with the union typically, whether to participate in Beamers. That too is a contributory plan. 2/3 of the employees in the Beamers retirement system are school-based employees. So that a lot of people don't fully, you think your snowplow drivers in the Beamer system. Yes, that may be true, but your paraeducator, your administrative support staff in your school may also be in Beamers. And again, 2/3 of the folks in Beamers are school-based employees. And during the transition under Act 46, there were some questions about retirement. Would people lose it? And the answer is no, that was protected under Act 46. We didn't want people to lose their retirement merely by virtue of schools merging. So we would, as you think about merging district from where we are now to something smaller, those are some issues that have come up.
Jeff, I'm going to just interrupt for a second. And as a lawyer, please correct me if I'm wrong. Just so people know, Act 46 doesn't exist anymore. It was session law. So these sorts of things would need to be built back into anything new that we do.
Well, actually, Title 16, 1801 to 1803 was codified, and those are the employee protections. So those are still in the green books. So yeah, and then these new entities became the employing entity under Act 153 or Act 46. The new entity was the employing entity on behalf of the school employees, and that's who they were bargaining. And so, truthfully, Becca and I were talking about this last night. We didn't have, there were hiccups here and there when Act 46 was transitioning, but in large, you have well-seasoned folks on both sides of the aisle trying to figure this out, trying to do the right thing, make sure that people were employed, remained employed, there was a collective bargaining in place on the day one, so that everybody knew the rules of the road. And that mostly took place. Were there hiccups? Sure, but we managed it. And again, collective bargaining took place between the school employees and their employer. Whether it was the new employer or not, it doesn't matter. It was always with their employer. So that was how that worked.
Jeff, do you think that the lack of hiccups in that was probably largely due to the fact that the groundwork had been laid years before by requiring bargaining at the SU level, and that most Act 46 mergers really were SUs becoming SDs, so they were already the contracts were there.
Yeah, I think that's part of it. Certainly it's part of it, right? There was a, say, muscle memory is not the right word, but certainly a familiarity with the entities. And if you're already bargaining with the SU, so for example, you might have 5 elementary schools in Washington Central, right around here. They had 5 elementary schools that each had their own school board, and then you had the U32. If you're familiar with it, you can, and they had a school board. So you had 6 school boards.
Then there was another board, the executive board. Yeah.
I didn't want to go there, but that's right. There were 7 school boards, literally, and that's now there's 1, and by virtue of Act 46. But we'd already previously been bargaining with Washington Central at the SU level. So to your point, Representative Conlon, it was pretty familiar, and it was different in other places. It wasn't always that simple, but in large measure, I think there was familiarity with the parties and the people and the structures.
And there were already broad contracts that had already brought together the 5 elementary schools and the high school under the same contract.
Correct. So, I think that you're right. Now, if you're going to go much larger, and that's what we're talking about here, you're going to bump into some concerns because you're right. We had previously had a lot of contracts that had already been merged together, and while you may have separate employing entities, they've been bargaining at the SU level. I remember one of the questions we had was if a school board, it didn't happen in Washington Central. I'll pick on them just because I know them, but if one of the school boards didn't want to bargain at the SU level, we had some of that occasionally, where you had a recalcitrant school board or a local. We managed that as well. It was not always perfect. It did happen, right? So people are people, and they do what they want. So that's what we've experienced. And a couple of questions you might have is as you move along is what concerns do we have? And once you go there, you get some thoughts about that.
Sure. I think part of Act 46 as well is that it stayed localized, and you continue to have that really, I think, important balance that Jeff mentioned earlier, that you have actually the educators that are in the building, know the students, know the climate, know what's happening, bargaining with the school board or community members, parents. That's a really important part of labor relations. Sometimes as a marriage without the possibility of divorce, you have to continue to work together. You make hard choices, you make concessions, and you're sitting across the table from your teachers and on the other side, parents, and you are teaching their children, you see them at basketball games. That's a really important relationship. And as you move away from that and you get to larger districts and you further consolidate, you're going to lose those nuances. And if you want something that's student-centered, you need the people that are closest to the students, okay? And if you get bigger, then you're lost in lawyers, which we don't want, lawyers bargaining across from lawyers. We've seen that in the statewide healthcare process, which I can tell you I've been a part of, and that is 4 days of fact finding and 5 days of arbitration and thousands and thousands of pages of exhibits. And it's lawyers talking at each other, and the educators and the school board members are lost in that process. And it's not healthy for our communities and for our students to move towards that. And you're really losing that sense of local control as well, and making those decisions locally about what communities want and what they value. And
I mean, just bargain, the further removed you get from the school, further away from the decision makers at that level, as it affects the local student and the teacher and the bus driver and whatever. Everybody's further and further away from the decision makers, are further away from the effects on the ground. That's a challenge. That is, we have concerns about that, and wanted to raise those with you, because it is not always in the best interest for the students, who are, that's what we're all about, making sure that they get what they need so they can become productive citizens, well-educated productive citizens. So that's the goal of the education system in large. How do we do that? And how do we achieve it with economies of scale and efficiencies and all those things? Those are tug of wars a little bit. So that's the real concern we have with going further and further away from the school setting, the decision makers, about how you collectively bargain.
I would also say each district and each school is unique, and Vermont NEA really is not involved until later on in the process. It's our members who are drafting their bargaining proposals, who are working together as teams, who are staying across from school board members and saying, this is what's happening in our schools every single day. This is what we need to focus on. Maybe we need more planning time, or we need greater protections if there's, safety issues going on. All of this is very tied to what the work that they're doing every day. And it's different in different areas as well. So
Appreciate that as a sort of counter argument to moving to larger and larger districts. If you could talk a bit about larger districts as a foregone conclusion and the complications of merging CBAs, that might help us understand, just from a process point of view, what it like. If we went to 10 or 15 or 20 districts, it's still a big deal process-wise in many areas. But I would think that very different CBAs would be very challenging to put together. And sort of what is the process for that?
So I don't know, much of the process would be hashed out here maybe, or
What we're looking for
House
is
General.
clear,
clear, clear, ambiguous guidance. I think it's
Yes.
Unambiguous, right? So, couple things come to mind when you ask that question. First off, you've got the U.S. Constitution, and there's the Constitution includes a contracts clause, as it's known, and it says no state, can make a law that intrudes upon a contract. So that's a constitutional hiccup, if you will. Right now, I think I saw we're bargaining 27 contracts this year statewide. I don't know if that was just teachers or support staff. There's probably about 70 different locals that we have. Most locals are consist of a teacher local and an ESP sports staff. So we probably have slightly over 100 contracts that would have to be merged. But then you've got, so say 27 are being bargained this year. You just do the math, and they roll. They're not always on the same cycle. So some are next year, some are the year after, and I don't know how many thereafter. Typically, a contract collective bargaining agreement is 3 years. Doesn't have to be. It can be 1, it can be 2, it can be 3, it can be 5. There's no prohibition on it being 5 or 2. It's just typically 3, and there's some labor law reasons why it's typically 3, but that's what we think of as 3. But they're usually on a cycle. So if you merge 4 districts into one, you've got 4 contracts for teachers and 4 contracts for support staff, right? So you've got 8 contracts that you've got to merge into at least 2, probably at that point. They all may have different expiration dates. So you've got to understand that you can't intrude upon their contracts that exist. And you can only say, yes, Rick.
Can union, like, can the local union vote to open a contract? Has done that before.
Yeah, I mean, both sides can agree to open a contract.
Okay,
Right?
okay,
Both sides would have to.
right, but
Anytime.
nobody can infringe upon contract.
No.
Right, got it. That would be voluntary and
On both
a
sides.
majority.
Right, the school board and
Right,
the local association would have to agree to
Right.
open up a contract for whatever reason. There may be good and valid reasons to.
Right.
One side may think there are good and valid reasons, the other side may not agree.
Right.
That's always a challenge perhaps. But so as the contracts expire, your laws could then impose upon the four entities, my hypothetical. And say, these are what we want from you in your contracts going forward. And somehow you get to merge them. And when you're right, it could be a challenge because there might be a 30-minute prep period in one contract and a 15-minute prep in another one. And they've got, that's much of what we dealt with.
To say nothing of different salary schedules that may exist.
Yes.
that's,
I think somebody the other day brought up who decides which seniority takes precedence over another. I'm just trying to flesh out some of these things that would go into having create going from to however many contracts you do went to. So we went to 20 contracts total across the state, 10 teacher, 10 sports staff.
Yeah, I was gonna bring up the seniority piece as well, because in some ways, that's an even more important question than how are we gonna merge the salary steps, because as we do these consolidations, that means not everyone's gonna make it through, and you would have in one contract and you won't in this contract. I mean, like, does it make sense just to go like the top from any school, 5 people in that order, but like, also not really, I mean.
But to be fair, at this point, all the proposal is bringing together is governance. There's nothing in, for example, the governor's proposal that talks about closing schools.
So I'll say this in Act 46, the seniority probably a little bit easier because we were a little bit closer, and I won't deny that. But I do recall one superintendent, I won't name names, who I thought did it very well. And what she did was she turned to the unions, plural, and said, "You figure it out. If it's reasonable, I'll accept it." And that worked. And I think some superintendents wanted to impose their will because they had certain people they didn't like, or whatever reasons. I don't know.
That's not a, sorry, I don't mean to interrupt, that is not a valid reason.
That's
That's what you
Yeah.
say. That's exactly what
Sorry,
you
I
said.
don't, I apologize.
I'm just gonna-
With you.
it's okay.
We're not negotiating here. We're just
No.
surfacing the challenges that would go.
Challenge. So what worked well there, I thought, was the superintendent saying to the local association, "Look, you figure out what works for you. So long as it's reasonable, I'm not going to second guess you." Because you're right, Representative Harple. It's going to be in a bigger district. That's going to be a bigger issue.
Mhm.
This was in a fairly small SU that was merging, I think, 3 elementary schools, a middle school, and a high school into one. So there was a lot. The good thing right now is we don't have an abundance of teachers or support staff. It's not as if
That's a good thing.
Yeah. right. I mean, that's been a challenge. So I think that seniorities may or may not be the issue that it potentially could be in a different economic environment. Let's say it that way. That may be a reality of the day.
We do have some contracts that I've worked with recently where they can't agree. And so certain schools have different provisions than the rest. And they, that's.
I just want to respond to your comment that like in an economic reality, that may not be the deal we think it is. I mean, like one of the things I've learned from my work is to think so far ahead because of precedent, right? Like it may not be a reality now, but we don't know what our economic landscape is going to look like for the next like 100 years, 200 years. And so like the decisions that we make now are going to be potentially looked back at as, oh, this is the way that they did things. So it does actually
No, I don't mean to say it doesn't matter.
Yeah.
I'm just saying, we might be able to navigate seniority lists.
Right,
Given that there are not an abundance. I was at a
Okay.
regional conference with
Yeah.
some colleagues from around the Northeast and Mid-Atlantic. I was blown away. I heard this. So Massachusetts, bigger, much bigger state, much different environment. Last year graduated 6 special education teachers in the entire state out of all their state programs.
They got a few colleges down there, I think.
So we talk about challenges and getting staff. It is not unique to Vermont. It's a nationwide problem. And I don't see it improving much. I've seen some economic, information that would say this is a long-term problem for the next 10 to 15, 20 years. That there's going to be an educator shortage. I think that's probably true. And I think that might allow us to navigate the seniority list, perhaps. I don't know, but you're right. It's a question mark. And it is not insignificant when you start figuring out, wait, they need to lay off 3 people. If you're one of the people who thought, wait, my old school, I was much higher on the list, and now I'm this new entity, I'm at the bottom of the list here. I don't like that. So that it is going to be difficult, perhaps in some situations. Yes.
I am thinking back to the days when I was negotiating contracts on behalf of my school board as we were going through the Act 46 process and trying to line everything up. There was an enormous amount of work. And we had to, we absolutely needed the help of an attorney. Do you have a sense of the landscape out there of, well, first of all, the NEA has to do the same thing because they're on the other side of the table. Do you have the capacity to assist your people if we were to go to 10 districts and we are doing all of that blending and merging? But also, what is the landscape of labor, educational labor attorneys in Vermont? I think the one that we use has since retired. I'm just want to get a sense of what you happen to know, just some insight.
I think we as an organization want to keep the bargaining local. We want our members to bargain and we assist. So I don't see the scenario where we want lawyers involved in doing collective bargaining on behalf of our members. So I think our position is that members should be bargaining, but the power is with them. And our UNICEF directors are really, who are like the representatives who work locally in the districts, are really the experts in bargaining. And I think that they would continue to function in that way.
I'm not talking about it's more like there's a lot of sort of legal and number crunching that has to go in there.
Right.
Yeah, I mean, I heard the other day you talked about accountants and lawyers. I'm an accountant, and I don't want to play one on TV, but so that's more of the school, I think, side that they would have to account for things.
Oh, yeah.
You've got, perhaps service debt on.
I'm really speaking only about labor.
Correct. No, I understand that. On the labor side, the lawyers on the other side, who represent schools, you're right. They're few and far between. And there's a shortage, I would say, there too. I know in chatting with one of them, he said he doubled his hourly rate on weekend calls. And he said he saw no reduction whatsoever in the number of calls on Saturdays and Sundays. It did not matter. So double your rate, didn't matter. Calls still kept, and he was trying to avoid calls on Saturday, Sunday. Didn't slow a bit.
But retired early dolls.
Right. That was in Cayman Islands.
It hadn't worked out for him.
So it does affect, right. There will be a demand on lawyers, and merging multiple contracts is difficult, as you might imagine. And trying to hash out language. This school board may have, and this local association may have felt very strongly of the language provision. And all the other merging entities could care less. How do you navigate that, right? You've got some really important stakeholders saying this is important language to us, and others saying, we care less. I don't know. And I think that's the job of both new entities, and to figure out what can they live with, what can they move ahead with, and what can they, jettison and to move the process along. That's a not an easy process. May need occasionally, some mediators, help the parties get to yes.
Also few and far between.
Correct.
If you want talking about fact finders, few and far between.
Correct.
So in sort of conjunction with a statewide foundation formula, many people say, oh, well, therefore we also really are going to need a statewide teacher's contract. I sometimes say, I don't even know what that means. Like, when that term is talked about with a statewide teacher's contract, who is the employer and who would you be bargaining with? What is your understanding of what a statewide teacher's contract means from an operational labor contract point of view?
I think it's borrowed from places that don't, from states who don't have collective bargaining, right? That they put in statutes. So I think that there's a sort of a misnomer there that that's the result of collective bargaining. Collective bargaining is between the union and their employer, so.
Yeah, Beck is right. The collective bargaining is between employees and their union and their employer. I don't know how it would work here, what you're, you may not know, and that's obvious. There's a lot to be details. Not obvious, you don't know.
We don't know.
Right. None of us know, right, what's going to come of this, but certainly, if you're merging, again, 4-8 districts or something like that, and you're going to say that's the employing entity, that's the entity with whom the local association ought to be bargaining the terms and conditions of employment to end up in collective bargaining. I think that's really significant, and the entirety of really what collective bargaining is. Having a third party entity bargain something that then imposes itself on the employing entity and the local association seems really incongruent with what collective bargaining is. In fact, it's antithetical.
I guess then, would you agree with me that the way you get to it, given those parameters, is that you really need both sides to sort of agree on terms that are the same across those 8 or whatever, how many districts. And that's, in the world of collective bargaining, the only way you're going to get to a statewide teacher's contract. So in other words, everybody, you've got 10 districts, 20 bargaining units, one for teachers, one for support staff. And everybody kind of says, we will do our best to come up with a contract that looks the same in each of our districts in order to have what would appear to be a statewide teacher's contract.
It's interesting. I mean, I'd like to, the details do matter. I can see a scenario where the merging entities give themselves time, right? So we're going to bargain this outline of a collective bargaining agreement, but understanding there may be some significant provisions in your old contract, if you will, that you want to maintain. We're going to give you 3 years or 5 years or whatever it is to sort of massage those and get to a place where we all have the same agreement that looks identical. Maybe it'll be hard to administer, perhaps. Frankly, be very difficult in some cases, perhaps. But it could be done to allow people space to get to a singular employment agreement between the new entity and the new local association.
But I don't think if you're looking across the entire state, that's going to happen. And that's a very, as you've said, you've bargained before as a school board member. I mean, you get into a back and forth of we want this, what's important to us, and each area is going to be different, and some things matter in certain areas that don't matter in others, and it's a very kind of exchange that goes on. What's prioritized and what matters to those people sitting at the table, and so to say what's happening at the table here is going to be identical to what's happening at the table here. I don't think that's realistic.
For the committee's benefit, the reason why I ask is because if you figure we have a statewide foundation formula where every student gets the same, amount of money plus weights, but you've got vastly different regional things when it comes to what you pay your public school employees, that singular foundation formula either needs to be adjusted or is out of balance across the state? That's my question. Representative Long.
I actually think you had your hand up first, sorry.
Well, I was debating, because I was thinking of it, same as you said, when it moved from district to SU, because the contracts, I mean, we were kind of the same, we had 6 different elementary schools, but my planning time wasn't the same as your planning time. And there were differences, and seniority was by building, so it didn't make sense for me to take a job at Lake Region High School if I went back to 0 and had 10 years at Barton. And when it went to the supervisory union, and they did that work about merging our wants and needs together. So it's kind of like you said, so then you take those districts, so maybe it starts at the district level and your districts bargain their agreements. It's not statewide. And
But then
over time, try to move to something that makes sense. So I guess I don't really have a question. I'm still just trying to process.
You always thought it was right?
So I'm kind of like, yeah, kind of thinking like you're thinking.
So based on, like Chair Conlon, I've had lots of experience at the negotiating table, and in my experience, as you explained, it's very helpful to be able to collaborate with our staff and come to a mutual agreement. And that's always been I deeply respect the process and have enjoyed it many times over the years. One of the questions, it's occurring to me right now, based on my past experience with 153 and Act 46, we were anticipating change before it actually happened. And as you said, both sides usually want to have a longer term contract. But we at times, and especially leading up to 46, I think, or maybe it was 153 too, we actually started to negotiate, both sides started to agree we're going to negotiate shorter term contracts so that we could get ourselves. Has that come into any conversations on your side? I don't know whether it has on the other side, but I'm just curious.
I've not
whether we're
heard it.
considering.
So what you're saying is,
It's a good question. Like, if it's not stable, right? If there's not
Yeah.
stability and you don't know.
yeah,
Right.
this is a new conversation. And I would say, I don't think I've heard anybody say thus far, oh, we're gonna try to shorten up this agreement to a 1 year so that matches up with our neighbors who are 2 years out or whatever. So we can align easier.
Yeah,
Or
it's
even just in
really-
a world of uncertainty?
Well, I mean, that's part of the reason why I asked the question, because I'm just wondering how much the world of uncertainty that we're living and breathing right now is in the field. And that's so.
There's
That's
a
just
lot
why
of
I
uncertainty.
asked.
So for example, just this week, a school issued letters of possibility of rifts based on the end of federal funding. Those, we don't know, but we're putting this in writing earlier rather than later. So there's a great deal of uncertainty. I think the answer to your question was nobody's thinking about collective bargaining and trying to align them.
Okay.
That would, honestly, that would take a place where there's trust on both sides,
That's what I'm-
trust in the system at large, trust at the system at the national level, trust that probably is non-existent today.
But you said there's 27 contracts up this year and stuff.
Correct. So those.
That's what I'm thinking. Thank you. That's what I was curious.
Jim, no. Brady and Hunter.
A clarification and then a question. I'm worried we're oversimplifying. This is probably more of a ways and means question, like foundation formula and contracting. I think 30 some states have foundation formulas. I don't know offhand, but I assume there are not statewide teacher contracts in 38 states by any stretch of the imagination. I don't know how many states, if any, have statewide teacher contracts. So there must be a world in which you can have the conceptual foundation formula and you can have on some level, whatever they are, however big or small, more locally bargained contracts. I think I just want to make sure we don't.
I think that's right.
Tying those assumptions together has me going, whoa, like then I don't know how we're ever gonna get anywhere here. If you're gonna assume we have to do this to do this. So I think I want to clarify that. I need to, as a history teacher, I feel like I should understand more about labor law. I'll do a little digging too, but with ways and means, but I don't think we have to assume the only way you can do a foundation formula statewide is a statewide teacher's contract. Like, I can't imagine that's what exists in 30 some states.
I don't think, no, I don't think it does in the 30 odd or. I can ask my colleagues and
Yeah.
Rebecca can ask others around the country to see how they do it.
I mean, really more of a question for Ways
It's
and
really
Means,
more-
but as we think
Yeah.
about the interrelationship of things, I'm worried about us having a
Yeah, well,
misunderstanding.
and I want to be also
Yeah.
clear with the committee that I just wanted to bring up a lot of this because next week we're going to have the language. And again, if we're going to try to stick to our philosophy here, we're always going to want to, as we look through the language of any bill that comes before us, we want to be clear that it's got clear and unambiguous guidance. And I would say, including as to how you bring together these issues. But I would say that in addition, if we're really going to take a deep dive into labor law, that's going to take place in a different committee.
Right,
Yes.
yeah. But my, so my question though would be, you know, one of the things that's been discussed in the governor's plan, and I think certainly just exists in the, is that we have a need to bring teacher salaries up, particularly in rural areas. And the, you know, testimony this week has been just heart-wrenching about the challenges they face, the amount of turnover, the amount of provisional licenses. I know very well in the field that somebody starts somewhere and then they, you know, come to Chittenden County. Do you see any potential, if you had fewer than 52, I don't know how many, but some slightly larger districts, that there might be some increased bargaining power in some larger rural districts that could potentially help create some, through collective bargaining and through natural forces, but to bring teacher salaries up a bit in regions of our state where it's absolutely needs to happen.
Potentially, you
Yeah, I
know,
think it's all hypothetical, right? We're all about raising everybody up.
Right.
Rob?
the one thing I'll say about teacher salaries, it's what sticks out for me over the many years of doing this is that it's more community based, right? So one community, it believes X and another Y, and that bleeds into the collective bargaining agreement, and it may be lower salaries and other conditions that works for that community. It's not to say it's right or wrong. It's just the reality of how it's locally. I don't know that will go away, whether it's a larger structure. It may capture greater community input that varies and might value greater salary or greater other things. I don't, the answer is, hypothetically, it's true that you could enjoy an increase in salary by virtue of the ability to bargain. You've got more access to money. Right?
I think we're way behind, so I was there. I really just wanted to give the committee a chance to
Thank
sort
you,
of
it's great.
understand a bit of
Yeah, thank you.
collective bargaining and challenges. With
Yeah.
so many bargaining units, just so many fewer bargaining units.
Thank you.
Thanks.
We're round.
Yeah.
I know it's short notice, but appreciate it.
Yeah.
All right, why don't we shift right into our next topic without shifting the Zoom. So along those lines, I've asked legislative counsel to come in, and just talk to us a bit about sort of what district consolidation has been, especially under Act 46, sort of the parts of the law that govern it. So we have a better understanding of what exists in statute today, and what is going to be in the language that we're going to hear Tuesday. So we're all sort of educated on the differences. Well, thank
Thank
you
you.
also for putting this all together on short notice.
Beth St. James, Office of Legislative Counsel. Please don't thank me yet. So I didn't prepare any written materials for you today. I have notes for myself that are not, I wouldn't love for them to live on your website forever, but should we get to that point, it's totally fine. So I thought what we could do today is just look at chapter 11 and title 16.
Big chapter.
Some of us still dream about. which is the Union School District chapter, and it governs how Union School Districts are formed. And then there's a whole separate, multiple subchapters that I don't think we need to get into today of once they're up and running, what does governance look like? How do they elect board members on an ongoing basis? How do they conduct their business? Is that helpful? Is that
It's helpful.
Okay.
And I just, for our own, talking about union school districts, talking about bigger districts. And actually, I think in the language we're gonna see, the same term is used, union school districts.
when you say language we're going to see, what are you referring to? Because I don't have any.
Tuesday.
Okay, okay. All right. So I thought, because I don't have like a slide deck or something for you, I would just pull up your website and chapter 11 and we'll kind of go through it. Does that work?
Great.
Okay. Ooh, can I get sharing permission, please?
Oh, yes.
Where do I find that?
Oh, no, no,
It's
no,
under
there's nothing.
statutes.
It's gonna go on the screen up.
Oh,
You
okay.
can
I thought
find
was-
it, so it's
I
under
can
Vermont
find it.
statutes, Title
If I go,
16,
yeah.
Chapter 11.
I can just.
I mean, I also.
Vermont laws,
You have Al's. Oh.
Vermont statutes online.
Good.
Okay, so we are in, you see, Title
Whatever
16.
committee you're in.
Chapter 11, Union School Districts. This chapter was rewritten in 2022. But the concepts here have been around for decades. This process, the details are far more detailed than they used to be. So again, when we talk about union school districts, we're talking about a school district that is responsible for the education of more than one town, right? So this chapter starts with a policy, which is really important because the approval of new union school districts under current law, and remember, you all write the law. So I cannot stress enough that what we are about to walk through today is current law and you have the ability to change it, okay? So a lot of what we're going to talk about in the formation of union school districts, there are various decision points along the way that require compliance with this state policy. So it is the policy of the state to provide substantially equal educational opportunities. Where are we getting that phrase?
Constitution.
Nope.
Brigham.
Yes. For all children in Vermont by authorizing 2 or more school districts, including an existing union school district. So a union school district can be formed by 2 towns who operate their own school district getting together. It could be formed by 1 town that operates its own school district and an existing union school district getting together and forming a brand new union school district. For the purpose of providing for the education of its resident students in the grades for which it is organized, and for the new union school district to be a body politic and corporate with the powers incident to a municipal corporation. Why is that important?
Because school districts are municipalities.
But why is that important? Why am I pointing that? There you go. With all the rights and responsibilities that a town school district has in providing for the education of its resident students. Formation of union school districts shall be designed to encourage and support local decisions and actions that provide substantial equity of educational opportunities statewide, lead students to achieve or exceed the state's education quality standards, maximize operational efficiencies, promote transparency and accountability, and be delivered at a cost that parents, voters, and taxpayers value. So when you hear me and you see it referenced in the statutes that we're about to walk through at a high level, state policy, this is the state policy we're talking about in chapter 11. I think we can skip over definitions, application of other laws. I think what would be most helpful to you is to just go through the subchapter 2, which is how a union school district is formed. So the first thing that happens is we've got to get folks who think this is an idea they want to explore. So we call that a study committee. So school boards of 2 or more school districts, and remember, that could be a town school district or that could be a union school district, get together the board's vote, not the voters, the board's vote to establish a study committee, which is going to do all the research and hold all the public engagement options to discuss formation of this new school district. Or they could be petitioned to form a study committee by at least 5% of the voters. So if 5% of the voters in the school district said, we really want to merge with our neighbors, get together and do it, but none of those neighbors want to do it, then there's no study committee. There has to be a meeting of the minds, right? Because this is an agreement to get together. Each school board each participating school district on this study committee is going to have proportional representation based on, and this is now outdated language that we need to clean up. There's no equalized pupils anymore. So weighted pupils, and the budget is also proportional. And then the law goes into detail about how interests are represented on this study committee, whether you're a union elementary or union high school or unified union. I don't think we need to go into that level of detail today. School districts get together, they decide they want to explore this option, they form a study committee, they've got members of their school boards appointed to that study committee. The budget and the representation is proportional depending on the school districts involved.
I just want to reiterate kind of a foundational concept here. This is all voluntary.
Yes, yes,
Right.
yes.
Can I just a quick, so, and I'm gonna try to say the statement like a sentence. But in this transformation that, we're seeing as a proposal, there would not necessarily be a study group or input from boards. Right?
Proposing a district, right? Not a-
He's just going bing, 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 bing. And we might say, well, it's a few more than that.
Why don't we,
Sorry.
why don't we go through this?
That's a good question.
Because that's a
All
big,
right.
that's a
That's
big
a,
point.
that's,
Okay.
yes.
Yeah, we'll talk about that at the bar or something. Okay.
I think the bigger question is, if we were to put in statute how many districts there will be, what does that do to all of this?
Right. Sorry, Beth.
I'm just gonna go back. And I think Chair Conlon has an excellent point that I should have grounded you all with. This is all voluntary. This is a voluntary process in Chapter 11. If you, the legislature, wants to create school districts, I still maintain my original position that the cleanest way to do that is through chartering. And chartering can look like a list, and it can look like the charters that you see for towns, right? There's different ways we can do that, but that's still kind of my bottom line. So they get together, they figure it out. The study committee is a public body, so it's all open meeting law, public records, all of that law applies. So let's see, where are we going next? Okay. Study committee process. This is kind of the meat of it. So without getting bogged down into the details of who's calling the first meeting or anything like that, they get together and then we have these concepts of necessary and advisable school district. So remember, this is a voluntary process. So the study committee is going to determine which school districts would be necessary to the formation of a union school district, without which the union school district should not exist or can't exist. And then advisable, like it would be great if you came along, but we don't need you to start. And so the study committee is identifying which of those school districts fall under which category. They don't have to be advisable school districts, but there do have to be necessary school districts. Okay. So if the study committee determines that it is advisable to propose formation of a union school district, then it prepares a report analyzing the strengths and challenges of the current structures of all necessary and advisable school districts. and outlining the ways in which a union school district would promote the state policy set forth in section 701, which is what we walked through to begin with. They also have to prepare proposed articles of agreement, which are the governing operational agreement. In the charter land, the charter would be the operational agreement. What does that report? And so a lot of times if you pull up a study committee report on your school districts, various school districts websites, there will be lots of things in there, but a lot of the meat of it lives in the articles of agreement, the proposed articles of agreement. So what needs to be in those proposed articles of agreement? Well, what are the school districts that are necessary? What are the school districts that are advisable? What's the new name of your school district? The grades that the union school district is proposing to operate, and the grades, if applicable, that it's proposing to pay tuition for. The cost and general location of any proposed new school buildings to be constructed, and the cost and general description of any proposed renovation to existing buildings. A plan for the first year of the union school district's operation for transportation, assignment of staff, use of curriculum. That all has to be consistent with existing contracts, collective bargaining agreements, and other provisions of law. Then once the school board is formed, if the union school district is formed, then the union school district board would make all subsequent decisions on those topics. The study committee is proposing in those initial articles of agreement that first year, what that first year of operation would look like. And that term operation is really important here. I want you to remember operation or operation. A list of indebtedness of each necessary and advisable district, which the union school district will assume. The specific pieces of real property of each necessary and advisable district that the union school district will acquire, their valuation, and how the union school district is going to pay for them. The representation model of the school board that has to be constitutional. The term of office for each newly elected member. The date on which the proposal to create the union school district and the election of initial school district members will be submitted to the voters. When's everyone going to vote on whether or not this union school district is actually going to spring to life? The date on which the union school district will be solely responsible for the education of its resident students and the grades for which it is organized, and will begin operating any schools, paying any tuition, and providing educational services. Whether the election of board members, school district officers, votes on the union school district budget, or votes on other public questions, or any combination thereof will be by Australian ballot, or is it going to be? Are they going to all be floor votes? And then anything else the study committee thinks is important. That's all of the concepts that the study committee has to flush out and build into their proposed articles of agreement before this even goes to, and we'll walk through the process of it have to go and be approved by the state board before it can even get to the voters. If the study committee gets together and says, it's not really advisable, then the study committee itself votes as such and they dissolve, they go away. End of story. If they do vote that it's advisable to form a union school district, then we move on to the next step, which is
Just yesterday, when we heard from Patrick Reed, and he talked about how Malnade tried to merge with Addison
Right.
Northwest. That was the process that we're talking about going through.
so from here on out, we're only talking about study committees that have voted that it is advisable to form a union school district. So they take that report and those proposed articles of agreement. They make sure all the school boards and all of the necessary and advisable school districts have copies of this. And they also send everything to the secretary, who reviews everything and then makes recommendations and sends the secretary's recommendations, the study committee report, and the proposed articles of agreement to the state board. Then the state board is charged with considering the study committee's report, proposed articles of agreement, and the secretary's recommendation. It has to provide the study committee an opportunity to be heard. It may ask the secretary or the study committee or both to make further investigation. It may consider any other information the state board deems pertinent, and it may request that the study committee amend the report or the proposed articles of agreement or both. Once the state board is satisfied with that process, satisfied that what it has in front of it is as far as it's going to get in any sort of back and forth, then if the state board finds that formation of the proposed union school district is in the best interest of the state, the students, and the school districts, and it aligns with that policy set forth in section 701, then it has to approve the study committee's report and proposed articles of agreement. And that's that. Then we're moving on to the voters. So vote to form a union school district. Again, we're not going to get bogged down in the election law. My goal here is so that you just understand the broad concepts. So remember, the articles of agreement had to have specified a date for this vote already. So we know when the date is going to be happening. It's the date that's in the final report. It has to be by Australian ballot. Has to be at separate school district meetings held on the same day. There has to be early and absentee voting provisions. And the board of each school district voting on the proposal shall warn the vote as either a special meeting of the school district or as part of its annual meeting. So all of the necessary and advisable districts vote on the same day. And they're voting on the same thing, the same proposal. Okay. The initial board members are also elected at the same time as the vote to form the union school district. And the law specifies the number of names, signatures to get on a petition, et cetera. We're not going to go through that level of detail today. Chapter 11 also provides what the warning needs to look like for this vote. And again, we're not going to go through it. I'm just calling your attention to it actually lives in statute.
That sounds like some clear, unambiguous guidance.
And then, okay, so there's a vote. What happens? Okay. Oops. So there's lots of recording of votes. Again, I'm going to kind of not get bogged down in who records what. If the voters in every school district identified as necessary vote to form the union school district, then it's formed. Simple as that. There's some requirements in here for where votes need to be recorded, but the kind of end of the line is the certification with the Secretary of State's office, which happens for all of our votes. Once the Secretary of State records that certification, then the union school district shall be a body politic and corporate with the powers incident to a municipal corporation, known by its name that the study committee picked and that the voters approved. It may be sued, it may hold and convey real property. It is a school district. Anyone want to guess if we go from certification to the Secretary of State's office to all these kiddos being educated in this brand new school district the next day? I'm guessing no. So, and again, I'm not going to go through the tallying of votes based on the proportional representation models for initial school board members. Just know that the law spells out very clearly if it's at-large representation or proportional representation, how do you count those votes and when are they sworn in? So you've formed this body politic, you formed this brand new union school district. First thing they've got to do is hold an organizational meeting to get their feet under them and figure out what they're doing. Yes.
Yeah, please.
So, I was gonna say, the ones that are necessary, if
Mhm.
they all agree.
Mhm.
But if someone who is advisable said no, it's still formed, but without them.
Correct. And if the
So if they
advice,
say yes, it's formed. with
correct,
them.
correct. And if one necessary community out of 5 votes no, there's no union school district. They'd have to start all over again. So the organizational meeting has to happen, within 60 days after the Secretary of State files, the certified, vote results. And here are all of the things, the business to be transacted. And again, I'm not going to get bogged into the details of who calls the meeting and who transmits the warning, et cetera. I just know the law spells all of that out. So they have to elect a temporary presiding officer and a temporary clerk. They have to adopt parliamentary procedures, most often Robert's rules, but there are other options. Don't ask me what they are. They have to elect a moderator. They have to elect a clerk. They have to elect a treasurer, and there is an option for appointment instead of election for those positions. They have to determine the date and location of the Union School District's annual meeting. They have to determine who's going to get paid. Are the moderator, clerk, and treasurer going to be paid? Are the school board members going to be paid? How and how much? They have to establish provisions for payment by the Union School District of any expense incurred or to be incurred by or on behalf of the district in between the date the voters approved in the first annual meeting of the school district. Is this initial board going to be able to borrow money? And if so, what are the parameters around that? There is a provision in law that even if that does allow them automatically to borrow a certain amount of money. And then they transact any other business that it was included in the warning, that the voters have power to transact at any annual or special meeting, and they can transact any non-binding business that may legally come before the voters. Okay, so that's the organizational meeting. Transition to full operations. So I think you heard, I didn't watch all of it, but I watched a lot of it yesterday, a lot of testimony of all of the business that goes into creating these new entities, right? Assuming liabilities, assuming property, all of these things. There needs to be a legal entity to do that. Mm-hmm. And it doesn't really make sense from a practical standpoint to be brand new one day and to have figured out all of that and then start providing education for your students the next day, right? There's a transition period built in here. And the operational date is the date, is the July 1 next following the date on which the voters approve formation of the school district. And that's when they start providing the education for their resident students. What happens during the transitional period? Well, all of those necessary and advisable districts that voluntarily voted to join, they're still in existence. And they are still responsible for providing for the education of their resident students until that operational date. The new Union School Board, while the old forming districts are out there just running day-to-day business, working with the new Union School Board on transferring everything they need to transfer, the new Union School Board has to develop the new school district policies, adopt curriculum, educational programs, assessment measures, reporting procedures. They have to negotiate and enter into contractual agreements. They have to negotiate and enter into collective bargaining agreements, set the school calendar for the fiscal years after the operational date, prepare and present to the voters the proposed budget for the fiscal year that begins on the operational date, prepare for the annual and any special meetings that may occur during the transitional period, and any other business that comes up before it. That's a lot, right? Because you're talking about, not only is that just a lot in and of itself, but you're talking about different school districts that have been operating for any number of time with their own policies, with their own curriculum. Now you've got one unit that has to figure out what are the policies and curriculum, not even taking into account all of the contractual obligations related to collective bargaining that you were just hearing about, right? Like setting all of that aside, just strictly figuring out policies and curriculum when you've got a bunch of different school districts who have been doing it their own way. How do you agree on that? So this is all the business they have to figure out before they're operational. During the transitional period and continuing until the voters approve a budget for the initial fiscal year of the operation, school board does have the authority to borrow sufficient funds to meet its pending obligations, right? We want this entity to survive. So we're gonna give it a, the law specifies you don't necessarily have to get approval from the voters to do that. Assets. So Chapter 11 spells out what to do about assets. So there's got to be on or before the operational date, the forming districts will transfer, and the new union school district will acquire ownership of all the assets that are owned on or before June 30th, immediately preceding that July 1 operational date. Unless basically everything we're about to talk about is unless the articles of agreement say otherwise. Forming districts are specifically prohibited from transferring ownership of an asset to an entity other than the union school district between the vote and the operational date. Trust funds, so if a forming school district had a trust, the new union school district is going to assume it, but it is to be held and applied pursuant to the conditions imposed, the terms before it was transferred, and the same for reserve funds. The new union school district is going to take on those reserve funds, but they are to be held and applied pursuant to the conditions imposed prior to the date in which the forming district voted to approve it.
I just want to pause for a second. And so when we think about moving to far fewer number of districts, these are all the things that come up. Oh, well, we've got this special fund that always pays for our after-school trips every year. This new larger entity will own it, but
They can't redirect
might
it.
be needed. Reserves are a big thing. And it is a new, much bigger entity. Capacity to manage all these individual reserve funds that are targeted for that particular school district.
Liabilities, it's basically the same concept. So before the operational date, the forming districts will transfer all of their liabilities to the union school district, and the union school district will assume them. The union school district will not assume liabilities that a forming district incurs between the vote and the operational date of the new use, so the transitional period, unless explicitly authorized in the articles of agreement or approved by the board during that transitional period, right? Life happens. Provided, however, that a union school district shall in all cases assume the contractual obligations of the member districts regarding each collective bargaining agreement or other employment contract entered into during the transitional period until the agreement or contract's expiration. And there is actually a whole separate provision related to contracts that we're not going to go through today. And then at the district's first annual meeting, following assumption of full operations or at a later meeting, the school district shall vote a sum sufficient to pay any unpaid balance of expenses that they incurred during that transition period. Okay, so what happens to those school districts once the new union school district becomes operational? It's a little different. It is different depending on if they were town school districts forming a union school district, union school districts forming a new union school district, union elementary. We're not going to get into the nitty-gritty details. This is just the broad concept, and that is the new USD, the new union school district, will supplant all forming districts on its operational date. And all forming districts will cease to exist on the new union district's operational date unless the articles of agreement have allowed them to exist for no more than 6 months, basically to wrap up business that the new union school district cannot legally ramp up. And then the only other piece that I have intended to go into specific detail on is just noting that then the state board is required to adjust supervisory union boundaries accordingly. And that is the current law, voluntary process for 2 or more school districts to get together and merge. And there is here, actually, let me share my screen so just so I can show you. So, pull out a little bit here. So subchapter 2, exploration, formation, and organization, we got down to section 719. There is a provision in law for joining an existing union school district. So you don't have to create a new entity, right? School districts could join a current union, so expand a union school district. Chapter 11 provides the process for that. There's amendments to articles of agreement, decision to vote by Australian ballot, and then there's a whole process for withdrawal from a union school district or dissolution of, if it's, then there would be no union school district. And then subchapter 3 is basically, okay, you've formed, you're operational now, you've gone through your transition period, but life continues to move on. How do we govern? Subchapter 3 is for unified union school districts. And then subchapter 4 is for union elementary and union high school districts. And it goes through in detail how you re-elect board members. What do the petitions look like for that? What happens if there's a vacancy? What does the annual report look like? And the same for officers, warning of school districts, all the voting procedures and processes, whether it's by Australian ballot or floor vote, commingling and bond issuance. And so this is, I like to say, one-stop shopping for anyone running a school district who has a question about school district governance for union school districts. And then this subchapter 5 is the ratification of districts formed pursuant to prior laws. And there's some language specific in here for the school districts that were formed pursuant to order of the state board after Act 46, which was not a voluntary process. But again, just this chapter 11 is current law, have the ability to change for school districts to voluntarily merge today. Is that what you were looking for?
That was great, actually, yes, to sort of understand today's context as we start talking about a future process and sort of what exists. I guess I would call that a very detailed, clear, unambiguous process. But it also sort of lays out just how complex it is. And that, you got the parallel boards operating at the same time, so you can have a transfer of everything in a, methodical way. So just, these are all things we have to think about as we start talking about a different setup.
Peter, if I can just
Yeah,
say,
please.
I have chaired a 706 study committee and still feel the pain from it a little bit. But I just want to say, in the process, if we didn't have an attorney to help us through, it would have been much more challenging. And I mean, this brought so much back. You probably chaired one too, I don't know. But it's
a lot to consider.
It's a lot. It's a lot, but it's very detailed, and I really appreciate the high level, but still getting into this was very helpful.
All right. We'll wrap there for lunch. I apologize, but we aren't back until 1:30. That worked, but that's because I have a meeting till 1:30.
Can I ask a question about that?
Oh, yeah.
So I'm seeing on our agenda that we have testimony and witness planning, but that GovOps is meeting with Senate GovOps and Senate Ed to discuss school district governance. Why are we not part of that?
I don't know the answer to that. And I'm not sure to what level they're speaking. I would welcome anybody who would like to volunteer to